Do you have employees or do you have independent contractors? The answer might surprise you today on the podcast.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome back to the podcast. We have a wonderful episode in store for you. We're going to be talking all about the differences between employees, independent contractors, how we get there, and why it's important. And then we kind of talk a little bit about a little bitty thing called AB5 out in California. If you are in California, you know exactly what we're talking about. If you're not there, please listen anyway, all the way to the conclusion, because guess what? What we're talking about with AB5 is probably coming at you as federal law probably in the next couple years, depending on what happens. I don't have a magic 8-ball, but it probably is coming at you. Anyway, before we get into that, please go over to my YouTube channel at Wedding Industry Law. Like and subscribe there. Leave a comment. If you have any suggestions for content, please hit me up. I'm on Instagram. I'm on YouTube. I'm at Taco Bell drive-thru. Buy me a gordita. I'm just kidding. I hate gorditas. Buy me a Doritos nacho cheese supreme Doritos Locos taco. I kind of got that messed up. A nacho cheese Doritos Locos supreme as opposed to a regular Doritos Locos taco. Anyway, with that being said, let's get into the content. So you've got people that work for you. Now, are they employees? Are they independent contractors? Who knows? We're going to hopefully shed some light on that today, but I'm not doing that by my lonesome. I have an excellent attorney out of San Diego, California, the big San Diego. His name is Braden Drake, and he's a wonderful human being for coming on the show. He has his own empire that he has built. I say his own like I have one. I don't have an empire. He has an empire. I've got like a little mound of dirt that I'm kind of pushing together like a little anthill. He has an empire. He is an exceptional attorney out there in California. He is a licensed attorney and tax professional, educator, and author. His tagline is "Your gay best friend, here to help you get your legal and tax shit legit." That's a mouthful. Braden works primarily with service-based, creative small business owners through his membership and course where he educates on contracts, business entities, cash flow, and taxes. Braden is the real deal, Holyfield. He has his own podcast. He has his own set of webinars. I suggest everybody go check those out. Those will be in the show notes and in the description of the YouTube channel. I always stumble through this. All that information will be located in the show notes of the episode to get a hold of Braden, and you're going to want to do that at the conclusion of the episode. So without further ado, we're going to get into the content. Braden, welcome to the show.
Hi, thanks for having me.
Awesome. I was saying before I brought you on about how much I enjoy your social media presence and like your website, and your whole brand is fantastic. And I'm working on a brand, like, you know, if you go to my LinkedIn page, it's like different colors and different things. And if you go to a website, blah, blah, but you're on that stuff. But that's not why we have you on today. We're really trying to figure out AB5. And then from a broader standpoint, like why any of this matters, like why are we talking about employees, why are we talking about independent contractors, that kind of stuff. So I wanted to have you on to work through this, what I would say is a mess. So for all of our listeners out there, these wedding professionals that think they have employees, or maybe they don't have employees, can you just, from a 40,000 foot view, explain what an employee is versus what an independent contractor is, and why do we even need to put people in these categories?
Sure. So generally speaking, an independent contractor obviously retains some level of independence. So the example I give a lot of the time is, like, I've hired a brand photographer, I've hired a graphic designer for my own business. Those are independent contractors. They have their own businesses. I'm not like bossing them around. I'm not telling them what to do. I'm not paying their payroll taxes. I'm hiring them. They're sending me a contract. Where we often see like a lot of confusion is when we get into subcontractors, which is like kind of another topic. But that would be generally if you're a brand photographer and you hire another photographer to come and help you because you're fully booked, that person's then a subcontractor. But still, they're not your employee, depending on the law. And that's where we get into these gray areas.
Exactly. Okay. So if I understand you correctly, you're saying, well, Rob, there is a certain level of possibly, I guess the word might be control, or the word might be oversight of one versus the other. Is that what I'm understanding? Is that a key difference between an employee versus an independent contractor?
Yeah. So in general, like common employment law, they call it the Berello Test. We won't go through the whole thing, but there's like 11 factors, and us attorneys refer to these as totality of the circumstances test. So you and I both know that means that the law just says there's a bunch of different factors. We're going to weigh them against each other. You don't have to meet all of them. But a lot of those factors really just have to do with how much control does the hiring entity have over the person that they're hiring, which would be the contractor. So if you get to make all the decisions and tell them you have to show up to work every day at this time, and I provide you your equipment and I'm going to train you and this is your hourly wage, that's an employer-employee relationship. Most of us understand that because most of us have been employees at some point in time before we started our own businesses.
That is, if that is the case for me, I can say that. I've waited tables, served pizza, everything running the gamut, construction, whatever the case. And I was definitely an employee in those situations. So
yeah, my last employment experience when I was studying for the bar exam, I worked at West Elm. Most people know what that is. It's an overpriced furniture store. So I go into work every day. I clock in. I get paid $11 an hour. I can't afford the furniture, and then I clock out and go home. Like that's how it works.
I want to say that there's a West Elm in Atlanta, but I might be wrong about that.
Yeah, I'm sure there is. Most of the big metro areas have one.
I think I've gone in there before, maybe once or twice. But yeah, so there's a totality of circumstances test. That's the legal jargon for it. But it comes down to certain characteristics that would separate an employee from an independent contractor, mostly having to do with control over the work that's being done. So okay, so the one thing that I would say, like the asterisk that I would put, and maybe you can speak to this a little bit, is one of the important things is that just because you say it is doesn't make it so. In other words, just because you're calling these people independent contractors doesn't necessarily mean that they are. They could be employees based on the 11 factors. Do I have that about right?
Yes, so that's correct. And I know you and I both talk about contracts a lot. So this is one of the few areas that you can't contract your way out of. So in all of our independent contractor agreements, even though we can't contract out of these circumstances, we always add a clause that says, I understand I'm an independent contractor. You're not going to pay my benefits. But even if someone signs that, if they don't meet the letter of the law as saying that they can validly be an independent contractor, then the courts don't care, the auditors don't care, they can be reclassified as an employee. And that's why this really matters.
Right. Okay. So before we get into AB5, which is California specific, so anybody that's not in California can probably zone out. But before we get into AB5, I guess the real question is why is it important to distinguish between the two? By way of example, does it have to do with perhaps workers' compensation insurance? Does it have to do with whether or not you got to pay them a fair wage, this type of thing? Can you kind of elaborate on that a little bit?
Yeah, so if you have a contractor that legally should be an employee, then you're opening yourself up to a lot of liability because at least California, I know, requires you to pay workers' compensation for all your employees. I'm sure pretty much every state does. And then once you have employees, you have to meet minimum wage requirements. So again, if I circle back, if I hire a website designer, typically they're going to make a pretty healthy hourly wage because they're smart business owners and they're going to structure their billing accordingly. But if I got quoted $500 by a brand new designer and they end up working 500 hours on my project just because they're new, they're not really making a minimum wage. But if that person were to be reclassified as an employee, that's like an oh crap moment that I need to be worried about. Then we also have like meal breaks, overtime, all this other kind of stuff as well. And Where we get in trouble is one of two ways. We can either get audited by a state agency that, has powers over these things, or if one of our former workers sues us claiming that they should have been an employee, then we can end up owing back payroll taxes for them and other benefits. And that's not very fun.
That is not fun. And I would say this too, and we'll get back to the audits and the lawsuit in AB5. But one of the major, at least in my anecdotal, unscientific approach to this with what I get from my clients, aside from that issue of back wages and making sure that people are paid a minimum wage, that kind of thing, where it really counts whether or not somebody's an employee versus an independent contractor is going to be when you drop something heavy on somebody's foot. Then it's going to really matter whether or not they're an independent contractor versus an employee, because oftentimes if the employee drops something on somebody's foot, then through the concept of what's called vicarious liability, that client or the bride or the groom or whoever it is that got something dropped on their foot is not suing that employee, they're suing the company that the employee works for, which is you, right? Whereas oftentimes that's not the case for independent contractors. So bodily injury is one of the reasons why I would say it's important for you being the listener, the business owner, to understand whether they have independent contractors or employees. Because typically tortious conduct, meaning negligent conduct, meaning you hurt somebody or your employees hurt somebody, it matters whether or not you're going to be liable for it. Okay, fair enough. Now, all right, you talked about, I talked about it. Let me throw it on you. AB5, for all of our people in California that are employing people, we'll just say people, who knows if they're independent contractors or employers or not, what is the significance of this particular legislation? Why should we be worried about it?
So lots of reasons, but first of all, I do want to kind of let everyone know, if you're listening to this podcast and you're not in California, you should still pay close attention. And this
always,
yeah, always. But Vice President Biden, who's currently running for president, has vocally supported AB5. The Democratic Congress has actually proposed federal legislation called PRO Act that would make this law a federal law. And a lot of individual states are passing it through their state legislatures. So essentially, California kind of always leads the charge when it comes to quote unquote workers' rights. But in this circumstance, let's just say the Democrats nationwide are wanting to pick it up. So if that happens, you're going to need to get up to speed quickly. So that caveat out of the way, what AB5 does is it essentially codifies a case that we had in the Supreme Court of California here a couple of years ago called Dynamex. And that's just a fancy way of me saying that the state, the big court in the state, decided a case that created a new rule for when someone would be considered a contractor rather than employee. It made it a lot more strict on, I don't even want to say employers. We always say hiring entities, because a hiring entity can hire an employee or a contractor. But it made the rule a lot more strict, and it only applied to wage orders, which is a very specific area of the employment code. We don't really need to get into that nuance either. But by passing this law, the state legislature basically said, we're going to apply this test to everyone, and we're going to apply it to every area of employment law. So now, rather than looking at those Berello factors we talked about earlier, you have to meet these very strict requirements under what we now call AB5.
Okay, and so if I understand correctly, then this stems from some Supreme Court case from some point in the past. Now it's been codified, meaning that it's legislation, it's the law of the land within the jurisdiction of California, and potentially it could be coming your way through United States congressional action. So definitely pay attention. So what are some takeaways from this for the average wedding planner, the average that is a hiring entity, as you just smartly say, that's a wedding planner or DJ that has 25, 30 people working across the state, or whatever the case may be? What are some things that they need to watch out for? Why should they appreciate this legislation?
So the biggest reason why is because the new test, first of all, this is a burden shifting test, which again is legal speak for, it used to be if a contractor were to sue you, they would have to prove that they are an employee. And now it's the hiring entity's business. So as the business owner, it's your burden to prove that someone is a contractor, which basically just makes it more difficult on the business owner. So that's reason number one. But the law created what they call the ABC test. So it's a 3-part test. Part A is the control test. It's basically like our old Berello rules. Do you control everything in this working relationship? Part B is the sticky issue, though, because Part B of this ABC test essentially says that you cannot hire someone as a contractor if they provide the same core service as you. So where this gets us into trouble is if you're a photographer hiring a photographer as a second shooter, you both provide the same service. They cannot be a contractor. They must be an employee. Same thing if a wedding planner hires a wedding planner. And I really like to emphasize this because a lot of people forget that we focus on all of the exceptions to these rules, which we can get into a little bit, but we forget about this actual rule. So me, an attorney, if I'm hiring a brand photographer, I don't have an issue. They can be a contractor. If my brand photographer hires another photographer to come and help her, then they need to worry about this ABC test. So that's A and B. Part C says that the person you're hiring must have an independently established business, more or less. So they should be doing the thing that you're hiring them for, like on a regular and continuous basis. So that's the ABC test. And then we have like a whole litany of exemptions and exceptions. I think we're up to like 78 at this point.
So, okay, that is certainly a mouthful. Now,
yes.
What about, I mean, is there any type of, in terms of exceptions, like, I know there's some, the Fair Labor Standards Act exceptions if you have a certain amount of people working, right? Is there not some type of exception if you only have 5 individuals as a hiring entity that are working? Does it matter?
No. So they actually, like at one point, someone proposed an amendment to exempt small businesses. And where they actually define small businesses as businesses making under $25 million a year, which is literally everyone I work with. But that never went through. So even if you only have one contractor during the year, you're still subject to this. And you need to look into, we do now have some industry exceptions for the event industry, for photographers specifically, but then there are additional requirements you have to meet in order to get that exception.
Is there a way that can you elaborate on those exceptions, the event industry exceptions and the photographer exceptions?
Yes. So people get really tripped up about this. I'm in a lot of different Facebook groups here that are like wedding industry specific here in California, and people will see a new exception. They get really excited. And then I'm always the buzzkill that's like, but you have to meet all these things. And typically, without going into every exception and every requirement, I'll kind of boil it down to this. Generally, what the state wants you to be able to prove is that this is a business-to-business contract. So if you are a photographer hiring another photographer, that other photographer should have their own photography business. They need to have a business license. They should be paying taxes. They should be, at a minimum, marketing themselves to other clients as a photographer. If they're not doing that, then they look like an employee to the state. So those are the biggest issues right there. Where we see this becoming a really big issue is like with wedding planners. It's very common to like hire your nephew who's in high school to come help you like set up tables on the day of the wedding. Your nephew does not have his own business, most likely. So that's problematic. So
stepping back into the shoes of the legislators, what is the policy interest that, in your opinion, that is being advanced by this particular legislation?
Okay, so do you want my actual opinion, or do you want me to tell you what they're saying?
No, I want you. I want your
okay.
Best. Yeah.
Yeah, so this is an interesting predicament, and if anyone follows me, they know I'm like very forthright with my politics. So I always share whenever I do these conversations. I've always been very liberal, like I'm pretty forward with that. So this is an interesting circumstance where a lot of the people that I've voted for are now passing legislation that I don't support. So it's an interesting catch-22 in this scenario, and I have a lot of friends that feel the same way. But essentially, the author of the bill, her name is Assemblywoman Lorena Gonzalez. She actually represents a district here in San Diego, where I live, in San Diego County. And she is backed by a lot of labor unions, and it's pretty common knowledge that the labor unions actually wrote this law, and she's kind of the torchbearer for it. So a lot of people have the common opinion, and I am in agreement with them, that they essentially want to really crack down on contractor scenarios, get everyone into unions. But this bill was in part drafted to really go after Uber and Lyft. They want Uber and Lyft to reclassify all their drivers as employees. So on a macro level, it's very focused on these big companies, but then on a micro level, it's affecting hundreds of thousands of small businesses as well. So right. They will also tell you, if you follow a lot of these politicians, that it's about people getting paid fair wages and getting all the other employment benefits that come with being an employee, like paid time off and those sort of things.
Right. I can understand this is where someone with liberal credentials is headbutting with, well, most of the time I'm in support of employees getting fair wages, but in this instance, you're throwing the baby out with the bathwater, I guess.
Because my argument always is, if you wanted to draft law that just ensured that even if someone's a contractor, they were being paid at least minimum wage or well above minimum wage, there are a lot of ways that you could draft that law without negatively impacting small businesses. And that's not what happened, unfortunately.
Or just off the top of my head, you can make it like, okay, well, if you have 1 million independent contractors, this applies to you only, right? And that's how you only get Uber and Lyft or whatever. It's the same thing I think that Virginia did to get Walmart. Like if you employ over 50,000 employees, this law applies to you. I don't know how constitutional that is, but anyway, yeah, no, I get it. It's funny that you mentioned this stuff, but that I went to school. I'm licensed in California, but I went to school, and most of my training is in Georgia. And it's the funny thing is that in law school here at Georgia State, several of my professors, particularly the ones that you take for corporations or tax or whatever, you're right that California leads the way in almost all areas of the law, but it'll always be, well, we got another case we got to read from the People's Republic of California, or, like the socialists over in California, we got to read this case or whatever. It's like, well, I mean, I guess if you want to be pejorative or whatever, but we always adopted Georgia 50 years later or 20 years later, it's coming to us at some point. So you're probably right. Like in some way, this particular state legislation will probably it'll find its way into the Fair Labor Standards Act somehow. And me being like the rational person that I always am, everyone's really been kind of protesting to abolish this law. And it's, my opinion is it's not going anywhere, because pretty much all of the Democrats, I think for maybe one, voted for it. They're all still in office. It's not going anywhere. But my kind of argument has been, let's do our best to get it amended so that it works as best as possible for small business owners. So that way, if it does get picked up on a federal level, we've kind of already done the legwork to make sure that it's not going to screw everyone over. Exactly. So in the last couple of minutes, Braden, what are some recommendations that you would give to an event industry business owner, a wedding business, wedding professional for AB5? What are some things that they can take away?
The biggest takeaway is just, if you think you are going to be remotely impacted by this, you need to do your own independent research. You can, of course, go hire an attorney as step number one. But if you don't want to take that as step number one, you should do some research, because I've done 2-hour live workshops on this topic, and we're still just kind of scratching the surface. So if people are interested, I have a pretty comprehensive blog post they can read. It's at www.bradendrake.com/AB5.
And I'll make sure that's in the show notes, and everybody please go and visit that. It is an excellent resource. I would highly recommend that you do so. And if anybody in California or wherever has any questions about this particular topic, Braden, how can they get a hold of you?
So Instagram's usually the easiest. I keep it pretty informal. So my Instagram is Braden Adam Drake. It's BRADEN. I would say Adam like the biblical figure, Drake like the rapper.
All righty. Thank you, Braden. And for everybody out there, you might be podcasted out, whatever. But Braden actually has an excellent podcast as well. I'm a fan of his. So please go out, and that'll also be in the show notes. I say show notes. I don't even know if people say show notes anymore. it's wherever you download this podcast. You'll see this information. Okay. So it'll be in there. And if you're watching it on YouTube, hopefully you're on YouTube. It'll be in the description down below. All of Braden's information, his webinars, podcast, all that kind of stuff, because he is an excellent resource, not just for California. Just check it out, even no matter where you're at. Awesome. And so Braden, that I think we hit the nail on the head with this one. Even though we're just scratching the surface, I think people have what they need to go about their day and figure out what they're going to do. So I really appreciate you coming on the podcast today. It was awesome.
Thanks so much for having me. I appreciate it.
Well, we hope that we were able to inform you and shed some light on some of this stuff and not necessarily scare you, because sometimes this stuff can be scary, but I think that, the more we know, the better off we are. And I'm so happy that Braden came on. He's such a good dude, very good educator. He really breaks down the complicated things into bite-sized morsels. So I appreciate his time to come out here and do that. Like I said at the beginning of the episode, go and check out his podcast. Go and check out his webinars. It'll be in the show notes. I highly recommend that you do that. And I think that's going to conclude this particular episode of the Wedding Industry Law Podcast. I'm going crazy. Hopefully you've made it to this far. I don't know. I think only my mom listens this much. Anyway, you can catch new episodes every Monday. And with that, I will see you next time.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.